Welcome everyone to our webinar on brand attack, what to do when your brand is copied. By way of introduction, my name is Sahil Verma and I'm a practice leader in the trademarks, IP and disputes team at LegalVision. Before we begin, just a couple of quick housekeeping items. So you'll receive the recording and slides in your email following the conclusion of this webinar. If you have any questions at all, please submit them in the Q&A box and I'll try my best to answer them at the end. And please complete the feedback survey after the webinar. It's really helpful for us. For the next 48 hours as well, you are eligible to receive a free consultation with LegalVision to discuss how we can help your business. Just simply provide your contact details in the survey at the end of the webinar. Before we start, just a quick poll question. Helps us inform, why you've joined this webinar today, kind of what impacts brand attacks are having on your business. So just to answer this simple question for us, if you could, what's your biggest concern when your brand is copied? Is it that you want to understand your legal position and your IP rights? Is it you want to understand the impacts that might have on your business and your reputation? Is it that you like knowing how to take legal action against copycats? Is it that you simply want to prevent future brand attacks? Or are you just curious? Are you just exploring and you have no immediate concerns? You're just kind of, informing yourselves for a future potential issue. Just take your time and just click the option that suits you best. Okay. Ooh, it looks like, just reading the poll results, it looks like the most important thing a lot of you want to know is how to take legal action against copycats. So that's good. That's quite a comprehensive part of this webinar today. So I'll definitely take my time when it comes to that part. Anyways, to open the webinar, today we'll be discussing brand attacks and more specifically, what courses of action we'd recommend taking when your brand has been imitated by a copycat. Generally speaking, when your brand has been copied, there are four major considerations. You should identify and assess your legal position and where you stand. This might involve, for example, taking a holistic view of what intellectual property rights you own. 2, you should identify and assess what impacts this copycat may likely have on your business and your rights and what the legal action is indeed justified. 3, if the impacts will cause damage, for example, to your sales or reputation, you should commence legal action, either informally or formally. And 4, following a resolution to the current issue, you should bolster your rights and legal protection for future potential attacks. Today, I'll take you through all 4 of the above points and answer any questions you might have at the end. So, what are intellectual property rights? Well, broadly speaking, IP simply refers to creations of the mind, such as inventions, designs, logos, names, or artistic works. IP that you create provides you with legal rights over its exclusive use and authorization, which prevents others from then exploiting those rights or potentially creating confusion in the marketplace. The main types of IP rights in the UK are patents, trademarks, copyrights, and design. Now, patents protect inventions and innovations. Trademarks protect branding, such as names, logos, taglines, symbols. Copyright protects literary or artistic works, and designs protects the visual appearance and aesthetic of certain products. For example, if I've invented a specific type of a lamp, patents will protect the lamp's functionality. Trademarks will protect the name of the lamp. Copyright will protect the text on my website used to describe the lamp or any artworks illustrating pictures of my lamp. And designs will protect the appearance or shape of the lamp. Now, as this webinar focuses solely on brands and others copying your brand, we'll spend the rest of the webinar focusing on trademarks and copyright, which are the main IP rights you'll need to consider if your brand is attacked. Now, when we talk about brands, there are many aspects that need to be considered. For example, a brand can encompass a name, a symbol, a logo, a tagline, a color, an identity, or a combination of all of these assets. Generally speaking, though, a brand should be able to be distinguished in the marketplace for that brand owner to hold the rights within it. For example, if I always use the color blue on my website, that doesn't necessarily mean that I own sole exclusive rights in the color blue to the extent that anyone else using blue is copying me. Similarly, if my business name is London Legal Services, it would be a stretch to believe my rights in this name are quite strong. This means that your legal position and your rights in a brand can vary depending on how distinctive or unique certain aspects of your brand are. So, if someone copies your brand, you need to question whether your brand is indeed distinctive enough to the extent that you own rights in it. If your brand name consists of a coined term that no one else has used, or if you've designed a logo from scratch, it's very likely that you have stronger rights in your brand compared to more generic brand assets that directly describe the goods and services that you sell, such as the barbershop, or use generic colors and symbols, such as clip art. Put simply, if there's an element of creativity and uniqueness to your brand, you are in a stronger position to stop others from copying it. However, just having a unique brand isn't the only consideration in whether your position is strong. You should ideally also have registered your rights within your branding or documented your adoption and use of that brand to date. Trademarks are just another term for signs or brand assets that you use to identify your goods and services in the marketplace. You can have unregistered trademarks or registered trademarks, but the latter is more desirable if you're keen on stopping others from copying your brand that you've created. Now, when you adopt a name or logo for your business, you start accumulating what are called unregistered trademark rights in that brand as soon as you start using it. However, these rights are not very strong. And the only way to ensure that your rights strengthen to the maximum extent possible is to register your trademark with trademark offices around the world. Registration will also grant you certain rights you otherwise wouldn't have had, such as the right to exclusivity for your brand and a defense to infringement claims being made against you. Copyright, on the other hand, doesn't need to be registered, and many countries around the world don't have an official copyright register like they would a trademark register. As such, it's important that you document when you first created something artistic, such as a logo, so that this can be relied upon in a copyright infringement claim when you need to demonstrate proof of creation and ownership. Now, let's say you've considered this in depth. You've come to the conclusion that aspects of your brand are being copied and they're unique, and you believe that you are the true owner of your brand. Now, you need to consider whether your brand has actually been copied from a legal perspective. Legally speaking, similarity is a heavily debated topic in the IP world. From a trademarks perspective, trademarks are considered similar to one another in the UK if they're identical or similar enough to cause confusion. However, you need to also consider the goods and services on offer. If the two parties using the trademarks are providing completely different goods and services, then perhaps there really isn't any foul play at hand. As such, you should compare whether the goods and services being provided by both parties are similar or likely to be associated with one another. For example, cosmetics are unlikely to be considered similar to financial services, but very likely to be considered similar to beauty salon services. So, if you consider the trademarks and the goods and services used by another business to be similar to yours, and you independently created your brand, and that brand is unique, then you are likely in a very good legal position to do something about it. As mentioned previously, though, your claims will be substantially stronger if you have registered your rights within that branding. Let's turn over to assessing the impacts that kind of the legal impacts that copying can have on your business. Now, before we consider the legal avenues available to you, we should first consider what impacts this infringement will likely have on your business and whether taking legal action is justified. Now, if someone copies your brand, the main impacts will likely be a loss of sales and consumer confusion, i.e., profits that should have gone to you are now going to the infringer because consumers are confused as to the origin of the goods and services that they're purchasing. Now, consumers are often have less trust in your brand after this occurs, and now they're less loyal to you moving forward. So that's an obvious loss of sales. But dilution can also occur, which means that your brand is no longer unique and you no longer have an exclusive monopoly to use it or to authorize the use of it to licensees, which means you also have a smaller market share. Other impacts could include a loss of reputation, which means, for example, the quality of your goods and services are deteriorating because of the infringing parties providing the same at a lower quality and therefore damaging your reputation. It can also damage your business relationships, such as your relationships with customers, investors, potential buyers, suppliers, etc. All of which would be wary that your brand is being copied and wonder whether your brand is indeed genuine moving forward. Lastly, some legal impacts could be increased business costs. For example, now you need to spend more on marketing and advertising because you need to promote your brand ahead of the counterfeit. So in terms of justifying legal action, you will need to now weigh the potential damages to your business against the potential legal costs required to take legal action. Generally speaking, legal costs associated with an initial cease and desist letter, which I'll go through next, are often worth the potential impacts to your brand. However, in many instances, escalating it to, for example, court or trademark opposition proceedings might not be worth it. And that's what you'll basically need to consider. Now, in terms of taking legal action, generally speaking, the first thing that you should not do is get in contact with the copycat, which sounds a little bit counterintuitive. But the first thing that you need to do is actually monitor the activity of the copycat and collate as much evidence as possible. Now, this might include, for example, taking screenshots of the infringement or documenting any instances of confusion. Once that's done, you will need to assess your own legal position by speaking to an IP lawyer. Now, the benefit of this is to understand if there are any gaps in your own protection and whether the other business might exploit those gaps or bring counterclaims against you. Your lawyer will also review the screenshots that you've collated to date and assess if there's actually a claim there. Now, if it's been established that there is a claim and you don't have any major gaps in your protection, that's when you can take legal action. And there's several informal and formal ways of taking legal action, which I'll now discuss. The main informal route is to contact the infringing party and put them on notice of your intellectual property rights, outline the impacts their infringement is having on your business, and then demand they cease and desist from using or copying elements of your brand in the future. Cease and desist letters are often an efficient way of resolving a dispute. And in many instances, the infringing party isn't actually aware that the brand that they adopted was indeed copied. It's also a relatively cost-effective way of ensuring that you protect your business in this situation. And it's actively encouraged by the courts as an alternative dispute resolution procedure. Separately, and especially if you don't receive a response to your cease and desist letter, you could also consider applying to take down the infringing party's online platforms. Now, many social media sites will allow you to report another account for IP infringement. And so this can be a swift and efficient way of ensuring that the other business stops using the infringing brand and attends to your concerns, especially if they've ignored your letter. You can also report users on marketplaces such as Amazon and eBay on a similar basis. However, unfortunately, sometimes informal routes are not that effective. Now, this is because essentially, one, they can be ignored in the case of letters, or two, irrelevant if the copycat doesn't have any social media platforms or online accounts for you to take down. Now, in a lot of these instances, it may be worth considering formal courses of action before the courts or trademark offices. Now, in the UK, court proceedings can be expensive, but are often the first formal action that you should consider if you intend to stop the other party from using a similar brand and providing similar goods or services. Courts can grant something called injunctions, which are legal orders that require a person to either do or not do a certain act. Courts can also award damages or order the infringing party to share their profits with you if it's determined that trademark or copyright infringement has occurred. However, apart from stopping another party's use of their infringing brand, in some cases, you might also need to stop their registration of that particular brand, especially via a trademark application, so that they don't also own registered rights in a brand that you've worked hard to create and control. Now, in these situations, you should consider filing a trademark opposition, which is a formal notice that another trademark should not achieve registration before the UK Intellectual Property Office. You'll need to file this opposition before the trademark achieves formal registration. So it's important that as a brand owner, you're actively searching the trademark register for similar names or logos that have been applied for. Separate from all of the above, and especially if you can't afford to go to court, you could also consider filing a domain name dispute to have the copycat similar website domain taken off them because of your registered or unregistered rights. Now, obviously, before commencing any formal or informal legal action, again, speak to a lawyer to understand your position, your strengths and weaknesses, and the potential costs associated with that particular avenue, and whether or not the costs outweigh the negative impacts. Now, let's say you didn't have the proper protections in place to stop another business from copying your brand. You sent a letter, they didn't respond, and because you hadn't registered any of your rights, you just didn't think it was worth escalating the matter to a formal legal action. That's okay. This time, you're in a better position to put the proper protections in place and ensure that if it ever happens again, your legal position is much stronger. Now, the first thing that you should always do is submit a trademark application for any and all brand elements that you own. Try and register your business name as a word trademark. All variations of your logos that you use and own, and I mean all color variations as well, and any taglines or product names that you use occasionally. Try and also ensure that you're selecting all relevant classes of goods and services on your application, and that the owner, either you as a person or your company, is correctly listed. Now, if you're unsure about this process, you should speak to a trademarks or IP lawyer, because getting this part wrong might have a negative effect on your position, 3 years down the line. Once your trademarks are registered, you should use the registered R symbol in your branding and business materials and ensure that moving forward, all of your registered trademarks are being used by the business in relation to all of the goods and services that you listed on your application, so that your registrations are not vulnerable to an attack on the basis of non-use. Trademark registrations can be removed if the trademarks that are the subject of those registrations are not being used anymore. You should also document your continued use of your brand and any reputation that you might accrue over time, as this will help you in other legal claims relating to passing off, for example. Lastly, now that your trademark protection is in place and you have a roadmap for how you will use and document your brand usage, the last consideration is monitoring. Now, monitoring involves routinely checking the marketplace, business directories, social media, trademark registers, and domain names for similar brands or trademarks. If you identify a similar brand, as mentioned at the start of this webinar, check to ensure if it's truly similar for similar goods and services, and if it is, we'll follow the steps that we've previously discussed. Well, that concludes the main part of our webinar. You might find our publication useful, Trademark Essentials UK. Just simply scan the QR code that's on your screen right now. Just a quick mention of the upcoming webinar that will be hosted by us next week, Tuesday, 18th of March at 11 a.m. the same time. You can register now for that webinar on Startup Essentials, How to Make Investors Love You. Simply register using the link on the slide that you can see. Lastly, and most importantly, I just wanted to quickly introduce you all to LegalVision's membership. Quick summary of it is basically it's a subscription to legal services, basically an all-inclusive. You get unlimited document review, unlimited trademark applications, unlimited legal advice in terms of legal advice consultations. You get employment support, access to 100+ lawyers that work at LegalVision on a guaranteed quick turnaround time of sometimes as quick as 3 business days to 5 business days. It is all inclusive. You have cost certainty in terms of what you pay each week or each month. If you are interested in joining or learning more about our membership, you can claim a complimentary legal health check. Just simply complete the survey at the end of this webinar. Okay. I'll answer any questions that may have been submitted during the webinar and prior to. Let me just have a quick look at the questions that have been submitted. How do I strengthen my IP rights internationally? Good question. A lot of the focus of this webinar has been UK focused. But obviously brands, especially in a globalized world, I mean, let's be honest, your brand can be seen and promoted internationally in as many countries as you take your business to. It's important that you basically take the crux of the principles that we've discussed today for the UK and apply those internationally. Obviously, there will be differences in how different countries, interpret trademark and copyright law and how they apply that. But the fundamental principles are all the same. And that's because a lot of countries around the world have actually entered an international treaty for copyright and trademarks so that a lot of these laws are aligned. But in order to strengthen your IP rights internationally, basically follow the same process, register your rights in the countries that you take your business to. So for example, if you're heading to the US, Canada, the EU, Australia, New Zealand, register your trademarks in those countries, document the creation of your logos in those countries and when you started using them, so that if anyone copies you, again, you're in a better legal position to do something about it. A second question here is, what should I do about someone copying my brand in another country? Quite similarly, first thing you should not do is contact that other business. Assess your own legal position, see what rights you do own in those countries, and then obviously follow those informal and formal legal avenues in terms of sending a cease and desist letter, applying for takedowns, or commencing court proceedings if obviously the matter escalates. Another question here is, how much do oppositions normally cost? So trademark oppositions obviously vary country to country, but in the UK quite specifically, it does normally depend on the stages of the opposition proceedings that you go through. As you can appreciate, you can file an initial opposition and the other trademark applicant might not defend it right from the outset, which means the opposition might cost you something as low as £500, plus the government fees of £200 sometimes. But obviously, if the opposition that you've launched is defended and it goes all the way to a hearing and you have law firms involved right from the start to the end, sometimes we can see oppositions generally go up to about £20,000. Again, a lot of factors that will influence that cost, such as how much evidence do you put on in those proceedings in terms of your 10 years of use before that, whether evidence is required, etc. But generally speaking, you can expect between, I guess, £5,000 to £20,000 for a simple opposition to a complicated one. Okay. Well, that's all the questions that I have in front of me. Let me just quickly see if there's another one. Do you have any clients who need VAT, EPR, and EU responsible person support when selling on Amazon? I'll answer that question. Thanks for that question. No, I'll answer that question. I'll reach out to you just separately because it's a little bit unrelated to the webinar at hand. Amazing. Okay, well, that's everything. Thank you all for joining today. If you do have any questions, please feel free to reach out. As I mentioned, you have a complimentary legal consultation, and I hope to see you at the next webinar. Thank you very much.